We'll have seen the title of this presentation focuses on UN mechanisms. The idea in this sort of opening lecture is to get a better understanding of the role of the United Nations in relation to minority protection, what has been achieved, what has not been achieved, what could be done better in the future, and even perhaps what is very unlikely to happen in the future. So the title is a bit provocative. It is not about praising or necessarily praising the UN for what have been able to do, but also, the idea is to identify the limitations of the various approaches so that we can understand what could be done, should be done better in the future, whether or not there's a space for it in the first place. You can see there's a brief selected history, so obviously before we move on to the United Nations proper, so the idea is just to give you an indication of what came before that. Very briefly, because of course, number one, I'm aware that not all of you have a legal background. As Anna Maria said, I'm a lawyer, so clearly I look at the legal dimension or dimensions of these processes, or try and capture the main narratives surrounding the law and try and put them within a broader context of international policy, international affairs. So what happened before the United Nations came in, and I'm talking about many stages go far back in history. We have at least two elements here that to keep in mind. One is the Peace of Westphalia, 1684, that basically ended the monopoly of the Catholic Church in Europe. It established a range of sovereign and quasi-sovereign entities within the European space, but more importantly, it introduced the notion of religious pluralism. It was not about minority rights per se, but it did establish the idea that if you are recognized, as you are to be recognized as a sovereign or quasi-sovereign entity, you have to respect the rights of minority groups within your own polity, particularly religious groups. So the idea of religious pluralism is important because actually it came to qualify the sovereignty that was being recognized under Westphalia. The second element that I would bring to your attention is the League of Nations system. After the First World War, 1919, you have a huge reshaping of the political and territorial landscape of Europe. You have new states, newly enlarged and reconfigured states, and of course with that you have minority groups. In other words, groups that became minorities as a result of this process of territorial reconfiguration. So basically, if I were to capture the essence of this process, it was a bit of a compromise. The League of Nations compromise, meaning minority protection in lieu of independence. Those minority groups who could not accede, who could not get access to independence, could not develop into an independent state, were given a number of guarantees to protect their rights of culture, their rights to perfect their religion, and so forth. And of course, this has to be placed within this broader context of national identities. Poland, for instance, was given a state of its own. So the Polish nationalism was rewarded in many ways, but Poland itself was asked to protect its own minorities within the newly established borders. We have a couple of cases here that you may have heard of as lawyers or researchers interested in minority issues. One is minority rights in Albania, minority schools in Albania from 1935, famously discussed and widely cited in the literature, where the Permanent Court of International Justice, which was the judicial arm of the League of Nations, discussed the rationale or rationales for the various minority treaties that were adopted under the League of Nations umbrella. And the idea was precisely to secure an element of minority protection so that minorities could live peacefully alongside majorities, even though those minorities were not being given a state of their own. The second case that I will bring to your attention is the All in Iceland case that came in a little bit earlier, in early 90s, involving the Swedish-speaking community of the islands. It used to be part of Finland, following Finland's independence from Russia, following the Bolshevik Revolution in 1917. So they wanted to be reunited with Sweden because they used to be part of the Kingdom of Sweden before the Finns and Russians came in. And of course that was based on national claims and national identities. The independence claim was rejected, but the two commissions that were established by the League of Nations in order to address the problem actually concluded that it was not okay for Finland to simply, establish itself as a Finnish nation. The Finns had to protect the language, the culture, the identity of the Swedish-speaking element of the islands. So again, you see here a compromise in terms of balancing out the interest there. The Finnish nation was recognized following the independence from the Russian Empire, while at the same time recognizing that nationalism could not be seen as a way of suppressing minorities within. And in that case, it was the Swedish-speaking element that came to be protected under that particular framework. But the old system, the League of Nations system, collapsed for various reasons, and I've listed here some of the reasons why it collapsed. It had a very limited geographical scope, so essentially the whole system was about Central and Eastern Europe rather than Western Europe. For instance, Italy was given South Tyrol, where a large German-speaking minority lives, but actually Italy was not asked to protect any minorities under the League of Nations mechanism. In fact, there was a proposal for it, and Italy resented that because they felt that they were a great power. So essentially, they said, how dare you ask me to do this? It's impossible. And frankly, the proposal was dropped. So in other words, there was a big divide between Western and Eastern Europe, and that was resented right from the start. Poland was one of the most vocal states in this sense. There was very limited, if at all, group standing. The groups could not directly petition the League of Nations. They could do this in a very indirect way, but essentially they had very little say. It was basically for the Council of the League of Nations to raise any issues of concern, perhaps for the Permanent Court of International Justice to intervene, but by and large, individuals and communities were being sidelined. Again, that was a flaw, a technical flaw, but also part of the political mechanism that had to be put in place. Behind all this, there was a strong untold story, and the untold story was that many Western countries, the UK being one of them, were clearly keen on assimilation. So the idea was that it's okay, we are going to have this thing to deal with Eastern European minorities, but in the end, minorities would assimilate into wider societies. The problem of minorities will disappear. And in fact, I think that this sort of normative assumption is still there in many liberal democracies. So essentially, many of these solutions were discussed and dealt with as pragmatic in nature and temporary in nature. On top of that, aggressive nationalism came in to essentially undermine the logic of the League of Nations system. You have the rise of fascism, the rise of Nazism in Spain, in Italy, in Germany, and so on. And the idea is to essentially annihilate minorities, any form of diversity, and of course the Holocaust and other barbarities in many ways confirmed that fear, that assumption that any form of diversity within the state should be removed. Now, in terms of international law, there's an interesting movement here between the state and the nation, because although nationalities and national identities were to some extent recognized, clearly the recognition was limited because, in effect, it never meant independence on purely national or nationalist grounds, while at the same time the state was not seen as a purely procedural mechanism, as something that you are given in order to simply establish the rule of law or to run proper institutions. has something to do with also the protection of diversity within. So you have this constant movement at the level of international lawmaking between the nation and the state. Neither of them prevails. Both of them contribute to the process. And this ambiguity between national identities, national identities, and statehood is still with us, in the sense that we don't know exactly which way we are going, precisely because we tend to be procedural, but also want to accommodate some of the issues that have arisen as a result of group identities, either on a national level, subnational level. So we have the United Nations, you can see there, or I hope you can, the UN era. That means essentially that with 1945 you have a paradigm shift. So it's something different comes in, and because of all of these things, assimilations, desires, pragmatism, all of that, the idea was to walk away from that paradigm in order to establish human rights for all without discrimination. The UN Charter is very clear in recognizing fundamental rights and freedoms without discrimination as to creed, religion, and so forth. But also the Universal Declaration of Human Rights from 1948 fails to adopt any meaningful provision on minorities. In fact, there have been proposals for some form of minority protection, looking at things like culture, language, religion, perhaps even public funding. But those proposals were put aside on the basis that non-discrimination would serve the interests of minorities as well. And that was clearly stated by Eleanor Roosevelt, who was chairing the drafting group on the Universal Declaration of Human Rights. I said, well, we don't need any minority rights. The Americans have always detested and always despised the notion of minority rights in terms of, protecting culture, protecting identities in the sense that we are talking about here. So they said, as long as you have a proper anti-discrimination system in place, everything will go, will be fine. And so the focus was mainly on non-discrimination. At the same time, you have this declaration adopted in 1948 by the General Assembly, actually on the same day in which the Universal Declaration was adopted, recognizing that the fate of minorities could not be ignored. So they essentially recommended the Economic and Social Council and particularly the Commission on Human Rights within that council to conduct a thorough study of minority issues. And this was the reason why you have this subcommission on prevention of discrimination and protection of minorities within the Commission on Human Rights. They were supposed to look at both faces, both sides of the problem, both non-discrimination on the one hand and minority protection in a specific sense of protecting the identity of minority groups or certain minority groups. Now, in effect, the main focus remained non-discrimination. There was a clear pressure to prioritize non-discrimination. We have John Humphrey, the first director of the Human Rights Division in Geneva, the United Nations, in the late 40s, saying very candidly in an article published in the American Journal of International Law in 1968 that there's never been any serious intention of doing anything at all about minorities. Now, of course, he didn't mean to say that non-discrimination was irrelevant to minority groups. He meant to say that there was no real appetite for any robust minority regime as a separate regime, a regime separate from general human rights, particularly the rights not to be discriminated against on a number of grounds. And so this was the normative assumption, normative background to the story. And frankly, this is what, in many ways, one might argue still happens today. Now, looking at anti-discrimination law and some basics, of course, feel free to raise your hand or put questions to me. We're going to have a big discussion at the end of this. So make a note of whatever you want me to clarify. But for now, let me simply briefly look at some of the pillars of this discussion. So anti-discrimination law has always been at the center of UN activities, and understandably so. So if you look at the various instruments and legal instruments that characterize the approach, so you have the 1965 ICER, the International Convention on the Elimination of All Forms of Racial Discrimination, that remains the most widely ratified treaty on this issue. Does it contain any specific minority rights provision? No, but it does refer to non-discrimination on a number of grounds, particularly ethnicity and national grounds or religious grounds and so on. So if you look at a general recommendation that CERD, the monitoring body established under ICERD, adopted in 1999 in order to identify the scope of application of this convention, it refers clearly to persons belonging to different races, national or ethnic groups, or indigenous peoples. That means essentially that the convention can be applied to a variety of groups, even though it doesn't contain specific minority provisions. So you have a general recommendation 97, for instance, focusing on indigenous peoples, discrimination against indigenous peoples as falling within the scope of application of the convention. So you have essentially this trend towards opening up the scope of application of the convention in order to address the issues such as indigenous rights or minority rights and so on that have arisen in the meantime. So you have this wider framework, but in the end, the idea behind it is to use equality and equality law as a general baseline for rights enjoyment. So in other words, for enjoying a common body of rights that cut across the human rights framework. For example, Article 2 and Article 26 of the ICPR, the International Covenant on Civil and Political Rights. So you have clauses that essentially recognize an obligation on states to secure the protection of certain rights as recognized in the treaty, for example under Article 2, or in national legislation under Article 26. So a particular right, for example social rights, may not have been recognized in the ICCPR, and yet if the state adopts measures that are discriminatory on whatever grounds, those measures can be challenged under Article 26, and in some cases those measures have been challenged precisely because of that. Now, two elements that might come into play in this discussion. One is the idea that anti-discrimination is not incompatible with differential treatment. The notion of equality in fact, as opposed to equality in law, formal equality, was first discussed by the Permanent Court of International Justice in 1933, and it has been endorsed by various UN bodies, including CERD. So differential treatment, the idea that you may need something different in order to secure a certain level of protection for minorities on the same basis as majorities is key to this discussion. So differential treatment does not constitute discrimination. And the other dimension, the other phase of this discussion is the notion of indirect discrimination. Again, recognized by our CERD, recognized by the European Court of Human Rights and the European Convention of Human Rights. What does that mean? Well, it means that the impact of public policies on groups has to be considered, has to be reviewed on a case-by-case basis. So you may have legislation that doesn't say anything at all about minorities, but it is bound to impact disproportionately negatively on minorities or particular minorities. So the notion of indirect discrimination is important in order to sort of unveil, in order to unmask, if you like, the hidden intent to discriminate against particular groups. And in fact, in the 1935 case that I mentioned, minority schools in Albania, the case was effectively about indirect discrimination. Albania had abolished all private schools, including minority private schools, and introduced a universal system of education with Albanian as the only language of instruction. Now, that was bound to have an impact on a variety of groups, but particularly on minority groups that used to run their own schools at their own expenses. So that differential treatment was abolished in the name of a policy that appeared neutral on its face. So you had an introduction of universal system that didn't say anything at all about minorities, so we are all fine, we are basically working on equal terms, no discrimination against anybody or any particular group. And yet the permanent court said, wait a minute, this may be true in theory, but in practice what has happened is that they are not allowed to receive instruction and education in their own language on the same basis had majority schools. So this idea of indirect discrimination has been recently recognized by the European Court of Human Rights in a number of cases, particularly against Roma groups across a number of European countries. And this has started to generate some anxiety within the European system, because clearly the focus is on collective dimensions. The idea that you have been denied access to education not because of your particular circumstances, but because you are a member of a Roma community that is defined by certain features and it is basically marginalized in society and so on and so forth. So they are starting to take on board all of these dimensions and looking at the impact of public policies on groups. That is very important and holds the promise of future developments within the United Nations and other systems as well. Now, one of the classic legal platforms is the notion of special measures. The idea, as ICERD put it in Articles 1.4 and 2.2, that if you are essentially adopting, say, quota in order to widen participation in academia, for instance, or if you are subsidized or if you are providing public funds in order to widen participation in society, that target specific minority groups, specific racial groups or ethnic minorities and so on, that is totally fine and totally compatible with the philosophy of the ICERD and human rights law. But look at this tension between non-discrimination and minority rights. In the General Recommendation 32 on special measures from 2009, the CERD makes it very clear that this must be distinguished from rights accepted and recognized by the international community to secure the existence and identity of groups such as minorities. So one would have thought that this idea of special measures was totally focused on minorities. And in fact, in many cases, it is focused on minorities. But that doesn't necessarily mean that we can sort of swap the two ideas. We can replace special measures or can sort of essentially look at special measures as if they were proper minority rights. And in that sense, CERD makes it very clear that the notion or the rationale for minority rights is that they tend to be permanent in nature rather than more transitory, as is usually the case. Special measures have to be discontinued once the objective of those measures has been achieved. Now, the ambiguities surrounding the anti-discrimination approach can be best illustrated by a case that was decided by the Human Rights Committee in 1999. The Human Rights Committee is the monitoring body under the ICPR, the International Covenant on Civil and Political Rights. And they decide on communications, so-called communications, put to them by individuals who feel they are victims of any breach or breaches of covenant rights. Now, in this particular case, the author of the complaint was a member of the Swedish faith in Canada, was sent his son to a private Jewish school. The school received no funding, public funding from the state. In fact, in Canada, no public funding is available for private religious schools, whether Jewish schools or any other religious denomination. Now, nevertheless, Roman Catholic schools receive public funding and they are effectively equated to public schools. They are treated as separate schools compared to other religious schools and therefore religious bodies running those schools. And he was questioning the legality of this distinction. The distinction is still entrenched in the Constitution and then implemented through provincial legislation. in the province of Ontario in particular. Now, so the issue was the exclusive public funding for Roman Catholic schools, sort of the differential treatment between one minority and the other. No public funding was available for private religious schools, and the committee concluded that there was a breach of Article 26 of the ICPR that recognized equality before the law, regardless of the rights in question. In this case, of course, the rights had nothing to do with the ICPR per se, but rather with the issue of public funding in general, because they felt that by distinguishing Roman Catholic schools as separate schools from other religious schools, they had introduced a differential treatment that had no reasonable and objective justification. It was a rather bold statement to make, not least because the very existence of Canada largely depended upon this deal, if I can put it this way, between the Catholic community and the Protestant community back in the day. So essentially, the finding was one of that discrimination, but the key point here is that they were not protecting any specific minority rights. They were looking at the issue of whether public funding was being distributed, was being allocated in a fair manner. So that's why basically they were looking at the how question rather than the if question. So in other words, they were looking at whether or not funding had been allocated on a non-discriminatory basis, rather than looking at the question of whether minority rights or any minority rights, whether the rights of Catholic minorities or Jewish minorities, should be protected under that particular provision. And this speaks volumes about the limitations of the equality approach. It is an important platform, it is an important basis, but it doesn't go beyond the minimum standard. And the minimum standard is that if the state has taken some action, for example, adopted a piece of legislation, the state has to make sure that this legislation that perhaps provides for some funding doesn't operate in a rather discriminatory way. But it doesn't say anything about whether or not any specific provision, any specific rights should be recognized for minorities as such. So in other words, it doesn't tell you whether, for example, religious schools had the right to public funding. In fact, one of the key points, controversial points that the Human Rights Committee made was that under the ICPR, there was, and probably they would argue there still is, no obligation upon states to fund religious schools, private religious schools in particular. And this may sound odd if we look at minority schools in particular. But nevertheless, this is what they said. So in other words, the Article 26 approach is good in terms of identifying the discriminatory implications of state measures, but it doesn't tell you anything at all about whether or not minority rights can and should be protected. So what are the limitations of the equality approach before we move on to some more specific standards? As I said, no claim to discrimination in general, particularly indirect discrimination, but I would say discrimination in general, can be made unless action has been taken by the state. So in other words, there's no way you can tell the state what to do prior to the state taking action. So unless the state has decided to do something about anyone really, all of us or a particular group, there's no way you can intervene in human rights law. So you have to wait for the state to do something, and possibly something wrong that you can challenge. Now, of course, there are exceptions to this paradigm. There might be clauses that say that the state must adopt this and that measure. Of course, this has happened in a number of cases, but by and large, in the vast majority of cases, the anti-discrimination approach does not provide any strict obligations upon states to do something specific unless, of course, the action proves discriminatory in one way or another. The same goes with indirect discrimination versus positive obligations. It's one thing to say that you have to remove that legislation in order to remove discrimination against, say, Roma groups. It is quite another to say exactly what the state is supposed to do about Roma groups. So it's two different things. There's an overlap between the issues, but technically speaking, if you, as a lawyer, want to argue a case before the European Court of Human Rights, you have to make sure that you have a valid legal basis for it. And there's very little in the way of an a priori obligation to do something other than, of course, through general human rights clauses. You have to protect the rights to freedom of expression and all the things that we know. But in terms of cultural identity or education, there's very little that you can say about, obligations, substantive obligations. So we step in, human rights activists and NGOs and lawyers, they step in once the action has been taken in order to identify any wrongdoing that may exist at one point or another. That also means that judges and policymakers may fail to endorse the group dimension. As I said, the Roma cases by the European Court of Human Rights have created a certain measure of anxiety across the system, because some judges are totally unhappy with this collective or group-oriented approach that says, well, they have been discriminated, we have the evidence here, we have statistical evidence, look at this, look at how segregated the schools are, because basically they are populated 90% by Roma pupils. So there must be something wrong with this system. And some judges say, no, sorry, we have to look at the circumstances of the individuals bringing the case. And therefore the individuals may or may not fit in with that paradigm. Now, obviously, it's a bit of a dilemma in terms of judicial policy, but it tells you the story of non-discrimination. It tells you the limitations of this approach and the fact that some judges may ignore the group dimension completely. Now, just to give an example, going back to history, in 1935, minority schools in Albania, you have many of the judges, the majority, pushing for this idea of equality in fact. And then you have the British member of the court saying, look, no, it's okay. This is a piece of legislation, the Albanian legislation that I was talking about before, that applies to everybody. So it doesn't discriminate, it doesn't target the Greek-speaking minority in that particular case. It doesn't do anything. It does what it says on the tin. So in other words, it does what it's supposed to do. It applies across the board and nothing else. So clearly there was a clash of ideologies. There was a clash of normative assumptions, as you said earlier. So in other words, what lies behind the human rights project and what basically we can make of human rights standards. And also, of course, the transitional versus permanent nature of anti-discrimination measures. The idea that, of course, you can do certain things, but you may struggle to keep those measures in place. Now, CERD has to say, has been rather flexible on this. They have interpreted the notion of transitory measures in a rather functional way. So they are not expecting, say, any admission quotas in university to be stopped immediately. They have taken a very functional approach, and they say, okay, this can be reviewed on a periodical basis. It does not necessarily imply that you have to stop it, say, within a matter of years. But nevertheless, the principle is there that says you have to stop it at some point. So, and in effect, if you look at the broader picture, the fundamental rationale for anti-discrimination is not in any way protecting minority rights. It is about assimilating individuals into a common framework. That is the idea, and that is the long-term trajectory. That's why the Americans like it, that's why the British like it, that's why many liberal democracies like it of a certain kind, because it looks forward to addressing the issue in ways that dilute and eventually remove diversity, ethnic diversity in particular, in the name of treating individuals, broadly speaking, in the same way. Controversial? Yes or no, depending on which part of the debate you are on. So, this is the story of non-discrimination. As I said, I promise you that I will stop in half an hour. We can have a debate, a robust debate for at least 30 minutes. Article 27, 1966, ICCPR, International Covenant on Civil and Political Rights. The United Nations felt that something more needed to be done, okay? That this subcommission on prevention of discrimination was looking at non-discrimination issues, but that sideline basically had sidelined minority issues. So you have Article 27, that is an attempt to contain the problem by recognizing that persons belonging to such minorities, by which they meant ethnic, religious, or linguistic minorities, shall not be denied the right to do a number of things, essentially to enjoy their culture, their religion, and their language. Now again, as you can see immediately from the language of Article 27, is very vague and very flexible. Now, what do we mean by minorities? Here we come back to the widely cited and widely criticized, but still there, Capotorti definition from 1978. The first UN Special Rapporteur on minorities was tasked with identifying the main ideas about Article 27. And basically, when you look at this idea of minorities, he provided some parameters, saying that basically by minorities we mean numerical inferior groups in a non-dominant position with a number of specific features, ethnic, religious, or linguistic, or combination of both of them, with a strong sense of solidarity directed towards preserving their culture, traditions, religions, or language. And that was in itself quite an ambiguous step to take, because in a sense it was a way of recognizing the uniqueness of those groups compared to majorities. And the way in which they did it was a bit ambivalent because of the way in which the groups had been singled out compared to majorities. But I will return to this more complex point at the end of this lecture. But this was the idea. And of course, over time, we have been overloaded with controversies and with dilemmas about the scope of application not only of Article 27, but many other minority rights. Anna Maria was talking about the Framework Convention for the Protection of National Minorities. I'm sure that Balash and others will be talking about that tomorrow, I think, and the controversy surrounding the scope of application. So by and large, there are a number of key areas of debate. One is whether or not minorities, as a legal term and a political term, refers to only traditional minorities, like the national minorities in European context, or whether they apply to immigrant minorities. We talked about migration crisis, migrants. Do migrants represent a minority under human rights law? Of course, they are a minority in the sense that they are in a vulnerable position. There's no question about that. Just as many other social minorities, sexual minorities, for instance, etc. But do they qualify for minority protection under this particular framework? And of course, people tend to take different views. Those views are mainly related to these two issues: whether or not long-standing ties with the state should be established before any minority status can be recognized, whether citizenship is needed, and also whether minorities should be looked at from a state perspective, so at the level of the state rather than the level of a particular region. There was a famous case, the Ballentine Case, decided by the HRC, where English speakers in Quebec, the French-speaking province of Canada, argued that they were entitled to protection under Article 27 as minorities. As you know, within Quebec there's a French-speaking majority in that particular province, and of course within Quebec you also have indigenous peoples, you have English speakers, etc., immigrants as well. So all of them, or some of them, are minorities under international law, under international human rights law. And the HRC took a very narrow view, saying that minorities are only those who qualify for a particular status vis-à-vis majorities at the state level. But again, the Framework Convention's Advisory Committee seems to have taken a more flexible approach, but it's much easier to take a flexible approach is to simply advise people to do something, because obviously you can advise all sorts of things and see whatever you want to see without really impacting the discussion in any meaningful way, at least in terms of law. So what is the point here? The point is that there's a lack of consensus, that there's a lot of contestation over this extended concept. Of course, we know what the core concept is. There's no way that many of the countries that have clarified what they mean by minority they have overwhelmingly referred to the traditional notion, whether it's Hungary or the Baltic states or even traditional Western countries. Look at Austria, look at Italy, and so forth. So in that sense, you can hardly say that there's a consensus in law. But there is quite a lot of consensus in expert circles on the need to extend the concept. So much so that in 1994, the HRC came up with this general comment, number 23, saying that, well, minorities should include migrant workers or even visitors. So people like me now traveling to Hungary may argue to be part of an Italian, I don't know, whatever grouping may exist in this country, so I want to be protected as a minority because of some sort of mistreatment I've been subjected to by the Tom Lantos Institute and the National University of Public Service. This will happen, of course, later in the day. It's not happening now. But, that is mainly the idea. And, of course, it is an idea that has been contested as well. Again, do we have a clue of what we are talking about here? I'm not aware of any major strong evidence suggesting that states parties to the ICCPR have taken this point on board. But again, the debate is still open. The jury is still out on this one. Minority existence, that's another thing which is important in terms of UN standards. Article 27 presupposes the existence of minorities on the ground, okay? So it says in those countries in which these minorities exist, states have to do something about them. Now, there are some countries, Turkey for instance, that have understood this idea as if it was for them to recognize whether or not any minorities exist, rather than leaving it to sociology, if you like, to history and whatever happens on the ground. Just to give you an example of two declarations that have been put forward in relation to Article 27, through which and by which states have sort of shaped up their own view of minorities. Turkey, in a famous reservation to Article 27, says, okay, look guys, I'm going to ratify the ICPR, I'm going to accept Article 27, but to me, minorities are only those minorities that are recognized in the Treaty of Lausanne, 1923. Now, Lausanne, as probably many of you, the background in history, sociology, anthropology, know very well, reversed the Treaty of Sèvres in 1920, under which Turkey, on behalf of the Ottoman Empire, had undertaken to protect minority groups, including the Kurds. Now, they won the War of Independence. They managed to push back the Allies who had occupied much of the crumbling empire, and they were able to successfully negotiate Lausanne in 1923 that says very little about minorities and focuses entirely on non-Muslim groups. And by non-Muslim groups, essentially they meant the Armenians, the Greeks, and the Jews. So that is the reason, the legal and political reason why Erdogan is still saying that we are, fine as far as minorities are concerned because we are complying with Lausanne. The Kurds are kind of vague entity, partly made up of terrorists, partly made up of, fanatics and so on. What we have to do is to strengthen the state and the Turkish identity. In fact, the Kurds, according to them, are nothing more than Turks of a different kind. So that's the main idea. But this is rooted in law. It is not just rooted in ideology. Of course, law as a reflection of ideology, but nevertheless, it is also rooted, strongly rooted in law. The second example is France, that doesn't even bother to recognize minorities, because Turkey at least recognizes non-Muslim groups and religious groups. But France, in another declaration that was treated subsequently as reservation, argued that the French government declares that Article 27 is simply not applicable so far as the Republic is concerned. So forget about minorities completely. So the Corsicans are not minorities, the Bretons are not minorities, and of course the immigrant population can hardly be treated as a minority, with all the implications that we are very much aware of. So here we have one step further, no minority status at all for any minority group. So you can see immediately the tension built into Article 27, so the idea that in a sense states are given a margin of discretion as to the recognition of minorities. Of course, the HRC has been adamant that it is not for them to do that. It is an objective phenomenon, as they put it, but nevertheless, it is possible for some states to sort of get away with this provision by simply shaping up their own views of what a minority is for the purposes of Article 27. Now, very briefly, some elements of the case law. I'm not going to discuss the details of this, just to say that there has been a trajectory that has progressively expanded the collective dimension of minority rights or Article 27 rights. Now, the classical case, or the textbook case, for any minority rights discussion, something everybody should understand and proper digest, is the Sandra Lovelace case in Canada from 1981, with a strong gender dimension. This lady had been denied access to an Indian tribe or an Indian band because she had married outside the community. She had married a non-Indian, and under Canadian legislation, basically she was no longer being treated as a minority woman. The committee sided with her, so basically she won the case on the basis that Article 27 had been violated. The focus was clearly on the individual, placed in a community context, but nevertheless the focus was on the individual. There was also a sex discrimination dimension that was somehow gently pushed to one side by saying that, okay, Article 27 has to be interpreted in light of non-discrimination clauses, but the focus was clearly on the individual. Now, in following years, Lubicon Lake Band versus Canada in 1990, and more recently a case against Peru from 2009, there's a greater emphasis on community identity and the need for protecting the group's way of life. Most clearly in the Angela Poma Poma and Peru case, that was about the diversion of water from the Peruvian highlands to a coastal city in order to support certain development activities. And the farming indigenous community had been living there for centuries, actually, had suffered greatly because of that. The livestock had died, and basically they were not able to raise the llamas, alpacas, and so forth. So they argued that this was a breach of the covenant, but they focused on Article 1, the right to self-determination. So they said this is basically a denial of access to natural resources and subsistence resources that are part of the right to self-determination in Article 1. The HRC looked at Article 27 instead of Article 1 because they say, well, Article 1 is a group right, a collective right, and this complaints mechanism applies only to individuals or individual rights rather than rights of peoples. But nevertheless, they did find a violation of Article 27 by arguing that the community had not been consulted prior to this project going forward. Not only that, but even they went as far as to say the prior consent to any measures that substantially compromise the group's way of life was required. Now, this is a very bold statement, in many ways a very promising one. Yes, it is tied up to or with specific economic activities, but it apparently applies across the board. So they mention minority or indigenous communities. They refer strongly to participation in decision making, and they say the consultation may not be enough. In some cases, free and prior consent is needed. Now, this seems to echo what the UN Declaration of the Rights of Indigenous Peoples says, as I will say later on. But nevertheless, it is an important step forward. Nevertheless, the procedure, as I said, as a whole, is available only to individuals rather than peoples or communities as such, so they have no legal standing before the HRC. Only groups of individuals could possibly argue that they are similarly affected, so they are pretty much in the same position, and they, as members of a particular community, have been affected by Article 27. So there has been some progress, but nevertheless, there are issues surrounding Article 27. And these are some of the main issues. Which minorities and why? Clearly, the focus is on ethnic or cultural minorities, but there's a bit of a confusion about what sort of minorities qualify beyond the minimum list of groups that we are already aware of, and why. What obligations upon states? If you look at the case law, clearly it doesn't say a great deal about what specific obligations are incumbent upon states. Of course, we know that there are minimum obligations not to assimilate the minority against its will, to protect them against private party intrusions, etc. But beyond that, when you look at education, language, religion, and so on, there's very little in the way of specific duties. There's also a sense that much of this case law has to do with indigenous peoples, which is a good thing. I mean, obviously, that simply means that, you know, indigenous activism has been far more effective than, you know, minority activism in Europe and elsewhere. So now we are starting to do something more positive with Roma cases and so on. But in general, I would say that indigenous people have been fantastic and incredibly efficient, incredibly good at putting together a network, a global network, that has made a difference. Whereas in the case of minorities or national minorities, I guess there has always been a tendency to fall back on the king state, on the state that they feel could eventually step in on their behalf at the international level. And this is wrong, because in the end, you can get things done if you organize yourself and you create those social movements Anna Maria was talking about in a more strategic way. So there's a question of whether this is about indigenous peoples, if there's some room for some kind of indigenous exceptionalism, or whether Article 27 can be seen as a platform for a common body of rights. As I said, some of the statements made by the HRC could be seen as rather controversial. On language, for instance, they seem to be taking a rather conservative approach in Ballentine in relation to, you know, the protection of minority languages in public sphere, etc., etc. So what are these minority rights for, after all? Are we simply duplicating what is already there under the banner of, say, heading of, or the rubric of, say, freedom of expression, freedom of religion, etc.? Are we replicating that set of rights, or are we saying that there's something different there? So again, this remains a bit obscure, not least because many experts tend to look at Article 27 as a fallback provision. So in other words, when everything else is unavailable or becomes unavailable, you fall back on Article 27 to make sure that things happen as far as minorities are concerned. So for example, if the principle of non-discrimination doesn't work, if anti-discrimination strategies don't work, if Article 26 doesn't work, then you still have Article 27. You can fall back on. The other thing is that there's a bit of an ambiguous relationship between Article 27 and the notion of self-determination in Article 1. Now, of course, we know that self-determination now can only be understood as internal self-determination, nothing to do with secession, although, of course, as we said, Catalonia wants to secede, Scotland has been contemplating that option, perhaps it will be back on the agenda at some future stage. Then you have Crimea, and then you have the Kurds. Now, the Kurds don't want to secede, they want to have abandoned the idea of creating a state of their own, but clearly there's always the prospect of secession independence is always, you know, in the background. Look at northern Syria, for instance. The Kurds in Syria, they wouldn't mind having a state of their own, whereas the Kurds in Turkey are more, you know, adamant that they want autonomy. They want some form of cultural autonomy, that some form of territorial autonomy. They don't want to break away with Turkey. Is it time for a new general comment? Perhaps this is something that we can put up for discussion later on. I think the 94 general comment is, to some extent, still there. We cited, we pay lip service to it, but frankly, I'm not sure that it has had a massive impact either on state practice or even the understanding of minority rights under Article 27. Again, something to be debated. Very quickly on what came after that. Of course, the collapse of Yugoslavia, Soviet Union, all the rest of it, meant that something more needed to be done. The 92 Declaration of Minorities was supposed to be, and is supposed to build on Article 27. As you can see in the preamble, it says that it is inspired by Article 27, and the rights can be enjoyed individually as well as in communities. Now, to be honest, there's not a great deal of progress in this declaration, although, of course, there are positive elements. For example, there's a more emphasis on the existence and identity of minorities as such. There's a greater emphasis on effective participation under Article 2 in decision-making on a central and local level. There's a duty upon states to create favorable conditions for mother tongue education. Clearly, any activity that goes against territorial integrity and sovereignty is unacceptable. So in that sense, it is a way of confirming what was already there, for example, no right to secession, but also a way of confirming the narrow approach to minority rights, no specific or explicit reference to self-determination, self-governance, as Anna Maria was saying, no autonomy specifically, but they do expand on some of the issues, specifically effective participation in decision-making, which is not spelled out clearly in Article 27. And there is a kind of more positive approach to recognizing and protecting the identity of minorities as groups. Now, that was 92, and of course in 92, the Balkans were in turmoil, as we know. As I said, the Soviet Union had collapsed. So clearly there was a sense that, you know, something more needed to be done. Frankly, I'm not sure that this declaration has gone any further, but it has created a platform for discussion. The second covenant has been also on the agenda, the covenant on economic, social and cultural rights. An interesting general comment was adopted in 2009 on the right of everyone to take part in cultural life under Article 15. Now, this used to be limited to high culture, artistic expressions and so forth. Nowadays, the notion of cultural rights has been expanded to include minorities, indigenous people, and so on. So the focus is on culture. Here, the narrative is not one of non-discrimination. The narrative is culture. The focus is on culture. And there are some interesting bits in this general comment, not least because there's a bit of a hybridity, a hybrid combination of individual and collective rights. We're talking about collective rights, liberal individualism versus collectivism. This general recommendation, or actually general comment, seeks to combine these two ideas. The rights are recognized both as individual rights and as collective rights, right to be exercised alone or in association with others or as a community. The rights of minorities and persons belonging to minorities to their cultural identity has been recognized. So in a sense, you have some sort of progress or advancement over previous ideas. There's also this theme of participation in decision-making, which I mentioned can be traced back to the 92 Declaration that says the rights of individuals and groups to participate in design and implementation of laws is important, and perhaps even free and informed prior consent is needed when their cultural resources are at risk. Now, as we know, general comments tend to include an element of wishful thinking, so you don't know exactly what states do with them, but nevertheless, it is important for activists, it is important for lawyers, it is important for those in civil society who operate in various ways, because basically they create a narrative, they create a space where you can develop ideas and perhaps push states in a certain direction. But I guess the point here is that Article 27 was then followed up by the 92 Declaration, and now we have this robust rights of cultural rights, the theme cutting across these legal instruments is culture and cultural rights. So the cultural approach in the sense of essentially protecting the identity in a very general sense. Now, my question is whether or not cultural protection is working. As you can see there, in the behind this black band here, the cultural protection working? And of course, as lawyers, we have to ask ourselves whether or not, for instance, the Declaration of Minorities has been cited anywhere in courts, in civil society. I'm sure that many of you will have noticed that and will have used it, but obviously it is an open question whether it can make any major difference. Remember, in technical terms, this is not a treaty, so it doesn't contain legally binding obligations. It is a piece of soft laws, a set of recommendations, guidelines for states who want to do something about minorities, who are serious about minorities, but if they fail to do so, there are no enforcement mechanisms, there are no specific procedures that can be used in that sense. There are also anxieties, conceptual anxieties about the role of cultural rights. Are we diluting stronger claims to self-determination, autonomy that clearly look at the political institutional dimension of the state, the legitimacy of sovereign authority? Why do indigenous peoples want autonomy? Is it because of their culture? Of course it is, but there's more to the story than culture. Why do certain groups in Eastern Europe want a certain measure of autonomy? Why do the Kurds want autonomy? Is it because of their culture? Of course it is. There's an element of language protection and attached to it, but there's much more than that. It is about the way in which the state was created, the powerful narratives, nationalist power, narratives of nationalism that essentially expelled or marginalized subnational identities. It was about the very structure of the state and legitimacy of sovereign authority. So it's a much more complex thing. Do cultural rights capture all of this? Many say no, there's no way they can do that. In fact, the focus on cultural rights is precisely to dismantle that narrative, to dismantle the idea that this is about not just minority rights, but the politics of minority rights. It's about the way in which we understand minority rights. It's about recognizing the complexities within the state. And one way of doing it is to overplay cultural identities and lumping a variety of distinct group claims together. So all of the minorities are pretty much in the same boat. So essentially a migrant trying to accommodate, trying to settle in a state and perhaps seeking some form of accommodation of their cultural identity is in the same position as an indigenous community seeking access to their lands or some form of self-government, or in the same position as, I don't know, some other traditional group who wants particular forms of territorial and non-territorial autonomy. Of course, these are profoundly different situations. But the way in which human rights law works does not necessarily understand that, does not necessarily accommodate that. It wants to squeeze everybody, literally everybody in every group, into the same framework, whether it's non-discrimination or culture, because that's the way it should work. So there are concerns about this, and of course I have no specific answers to offer other than suggestions and comments. So very briefly on indigenous rights, but I will really brief. This hybridity is clearly reflected in indigenous rights because indigenous peoples are peoples in the sense of communities that are more than minorities and minorities themselves, because in effect they have been very good, as I was saying before, at exploiting all the minority rights mechanisms, particularly Article 27. They do have their own instruments, as it will be noted later in the day, the UN Declaration of the Rights of Indigenous People from 2007, ILO Convention 169, International Labour Organization Convention 169, plus a number of general human rights treaties that have started to address the issue of indigenous rights, particularly under the Inter-American system, but more recently under the African Charter on Human and People's Rights. And there are also important elements of practice coming out of institutions, particularly the World Bank. There was an operational policy 4.10 from 2005 that was recently revised. There are mechanisms that can actually link up the provision of loans to the respect for indigenous rights or local communities. There are a number of things that are available and specific to indigenous peoples. And of course, the narratives and the themes can be traced back to self-determination, autonomy, colonialism, racism, post-colonial domination, much more than culture. But of course, culture is part of the story, as is land and participation, access to justice, and so on. Just to give an example, more recently, American Indian tribes of North Dakota wanted to something in terms of protecting their lands and so on, indigenous group from Brazil. We hear stories on a daily basis about indigenous activists being kidnapped or being killed or being mistreated, or projects being financed by the state with no consultation with the community. So clearly this is a big story. It has to do with the way in which the state operates, and of course, in our case, the extent to which human rights and human rights law can work. Very briefly on the Declaration from 1997, the difference between the two declarations, minorities and indigenous peoples, can be clearly measured in terms of the level of collective protection that is afforded to indigenous peoples compared to minorities. Indigenous peoples are peoples under the terms of the convention, not just persons belonging to. The focus is on internal self-determination, specifically internal self-government. There is stronger emphasis on participation rights, which applies across the board, but here with a clear focus on free and prior and informed consent. There are provisions on land rights, both in terms of protecting current lands and lands that were taken away by the indigenous peoples in the past. Now, in this particular case, there's no automatic entitlement to the land, but rather a process through which they have to, and the state has to go, has to comply with in order to address the validity of the claims. And in fact, we have important judgments coming, for example, from the Inter-American Court of Human Rights, where this element of redress has been clearly spelled out and elaborated upon. No right to independence, no right to secession. Indigenous peoples, many indigenous people couldn't care less about it because, frankly, no one has ever wanted secession or independence, although there was a principled discussion about self-determination, with many indigenous representatives arguing that if you are going to give me the right to self-determination, that has to be, that has to come with the whole package. So in other words, both external and internal, even though, of course, I'm not terribly interested in the external dimension of it. But nevertheless, eventually they settled on a narrower notion of self-determination in the sense of internal self-government. Okay, so this is just a brief thing. Very briefly on some cross-cutting issues, individual collective rights. There's an element of hybridity coming in. In terms of minority rights, they are overwhelmingly individual, but nevertheless, there are bits and pieces of the framework that tend to expand on collective rights. This is much more clear in the case of indigenous peoples. The baselines are essentially non-discrimination and culture, self-determination, autonomy. The political institutional dimensions are obviously in the background, and there's no chance, in my view, that the United Nations will ever be in a position to recognize that. Nevertheless, we have a number of hybrid spaces for discussion in terms of definitions and norms. One of the key points here is that the ambivalent position of international law. So in other words, you never know what international law is up to when it comes to minorities. They have shifted the focus from non-discrimination, so that they move from non-discrimination with a stronger emphasis on integration, which essentially means some form of soft, or potentially means some form of soft assimilation, to pragmatism and peace settlement. So you move from lofty ideals within the United Nations, focusing on non-discrimination, racism, all the way to, say, Dayton 95 or the Good Friday Agreement in Northern Ireland, etc., and many peace settlements around the world, where essentially communities have taken up arms, they've started a civil war, and of course something has to be done on the ground, and we constantly shift the emphasis. Anna Maria was talking about justice and security, and this has very much to do with these ideas. So international law is somehow in the middle, doesn't have a clear view, and it constantly shifts one way or the other, depending on the situation. But there are also ideological anxieties that, in my view, account for this hybridity. What are the human rights trajectories? There are at least 3 human rights trajectories. One is to simply focus on mainstreaming group identity. We have quite a number of cases that do not necessarily look at minority rights. They look at, say, things like respect for private and family life, right to life, and other things that are scattered throughout the human rights framework in various conventions. And many of the courts and bodies are trying to sort of stretch these categories in ways that can accommodate indigenous issues. We can keep doing this in the future. The other is to enhance special protection for particular groups through minority rights, say language education that remains essentially underdeveloped and underused. And the other possible trajectory is to revisit the logic of majority-minority relations through the lens of internal self-determination and intergroup diversity. This is a much more ambitious policy, intellectually much more demanding. I'm not sure that there's any experts who can actually take up this idea other than by saying that we have to go for an integration and assimilation. But as Anna Maria was saying, there's a bit of an ambiguity in that concept. Interculturalism may be seen as favoring or going against minorities depending on what sort of interculturalism you have in mind. For example, there's an important strand of scholarship in Quebec focusing on a certain version of interculturalism that says, okay, the French-speaking majority will remain dominant, so there's no question about that. So that is part of the history of the region, but we have to be open and flexible, and we have to absorb the migrant population in ways that will become a more diverse policy. They are not giving up on the idea that the majority in the region should be protected in what constitutes the main identity of the group, particularly language. Whereas other forms of interculturalism that have been put forward through the Council of Europe at areas, frankly, are much more ambiguous on the long-term objectives. The long-term objective seems to me assimilation of some kind, so that you will learn the lesson over time. I will civilize you. I will basically teach you the rule of law, and at the end of it, you realize how stupid you were when talking about ethnicity, all these things that don't make any sense at all. So there are these important conceptual variations, and one has to be very much aware of this. What are the strategies? And this is for you. Do we enhance anti-discrimination law? Do we go for enhancing Article 27 with a general comment? Do we draft a global convention? There's no such thing at the moment. Do we push for strategic litigation along the lines of what we have done with the Roma cases? The European Roma Rights Center has been extremely effective in doing so. Do we target specific institutions to push for more action, whether it's the Forum on Minority Issues or the expert mechanisms on the rights of indigenous peoples? What is the best strategy? Or is it a bit of a combination of things? Of course, one thing doesn't preclude the other, but again, we have to be aware of the possibilities. I will come back to this in 2 minutes because the final slide is precisely on the more sort of normative assumptions of the field. There are 2 problems here. When the fundamental problem, as I see it, is that identity has always been a bit of a nuisance for liberal human rights lawyers. So in that sense, we have this constant debate behind the scenes between sort of liberals and cosmopolitans and those who argue for a more collective approach. The classical liberal says that collectivism is nonsense, is inherently illiberal. Other liberals say that this is nonsense, that what they are proposing doesn't really reflect the reality of states, the reality of group identities. And you don't have to be a xenophobic nationalist to argue that national identities do have a place, a legitimate place in international affairs. So if you look at the works of highly distinguished liberals, from Isaiah Berlin to Michael Walzer and many others, you will see that this has been clearly. Michael Sandel, teaching at Harvard. You don't have to be a fanatic to argue that there's more to the story than individual liberty in the sense of, let's go for individual rights in the most generic sense. But I'm afraid that the United Nations tend to focus on this. And so there's a problem there, what we do with human rights law. And of course, the role of human rights law is to reshape, to some extent, to reshape sovereignty. Remember, international law was not about human rights when it started. International law was about states and how states relate to one another. It said very little about what happened within states, okay? So human rights law was a counterpoint to the traditional view of international law, okay? So it's a bit of an oddity within the legal framework, because it basically says how states should run their own affairs, which is, of course, a rather ambitious task. No, how should they run their own affairs when it comes to minorities is even more challenging. So there's an obvious task in terms of reshaping sovereignty, but also, in my view, to revisit the whole question of intergroup diversity, the way in which majorities need to be protected and the ways in which minorities need to be protected. And of course, if we talk about majorities also only in the sense that minorities have to disappear, then we have a problem. If we understand the logic of minority-majority relations, then we start, getting a better understanding of what is at stake. Now, I guess the point here, that is the final point, is that my sense and my fear, and as I mentioned right from the start, this is not, the lecture does not end on a positive note, a rather pessimistic note. My fear that this is going back to 1945. This is clearly going back to 1945. The American assumption back in 1948 that you don't need any minority rights because at the end of this process, non-discrimination will save the day, will create a liberal order that will, in a way, respond to the concerns and interests of minorities. History has proved them wrong, and I suspect that history will continue to prove them wrong in the future. So we are back to 1945 style UN, and I suppose that UN failures will have to go with it. But as I said, I'll stop here, and perhaps we can have a discussion about these questions to see if there's any space for improving the situation as you see it. Thank you very much.